and they're a tip earner, then you need to do a further case-by-case analysis. And I would suggest contacting an attorney who can go through that with you and look at the wage statements and figure out for the last 6 months how those tips interact with that employee's regular rate of pay. The next question on here, we just cut staff hours from 80 to 50 biweekly hours. So essentially going from a 40-hour week to a 25-hour week. Do I have to pay the sick leave for the total of 80 hours or 50 hours? How does that interact? If the employee is no longer full-time, because under these rules, we have a salaried full-time employee or a full-time employee working 40 hours, that is the regular normal amount of hours we're expecting to work. If we're reducing it to a very fixed number, 25, then 25 becomes the new normal when determining how many hours an employee works within a 2-week period. If we're reducing the number of hours and it becomes variable, where it's not a fixed number, then we need to use this 6-month look back. So you want to use the new set hours if it's fixed, or if it's variable, then you have to do an average going back and looking back historically. Because this is about prospective wages and about what the employee is missing out on because they're sick now. The last question on the slide is, if you've already provided 80 hours of PTO a year, but employees have used all or most of it, do you have to provide more? Yes. This is in addition. These hours under the emergency paid sick leave is in addition to any company policy that you might have, which is equal to or more generous or less generous than the emergency paid sick leave. So imagine if you had no PTO policies or sick leave policies, or if you had amazing PTO or sick leave policies. This is one more added on top of that. Next, we're going to get into intermittent leave, and Karen's going to handle this slide.
Excellent. Thanks, Sean. So intermittent leave, as we talked about on Tuesday's presentation, intermittent leave is only going to be triggered in sort of 2 scenarios. One is the employee is able to telework, right? So they could work from home and they could still, there is work available, right? They are teleworking, or they have the ability to telework. But maybe they cannot work a full day, either because they could be experiencing symptoms and maybe they can get some work done, but not a complete full day work done, or perhaps the childcare obligations interfere with their ability to get in a complete day, but they can do some of it. Intermittent leave does not apply where an employee would report physically to a work site and has symptoms or has been diagnosed or suggested to diagnose or to shelter in place, because actually has a COVID-19 illness. And this goes back to wanting to avoid the spread of the virus. So for a salaried employee who is taking intermittent extended family leave, how do we deal with or even the paid sick leave, how do we deal with their salary? So here's the best way to explain it, right? So you have a salaried employee who works Monday and Tuesday. Wednesday morning, they start feeling sick and they come down with, they think they've got the symptoms and they're going to start seeking a diagnosis. And so for Wednesday, Thursday, and Friday, they are seeking a diagnosis or have otherwise been advised by the doctor that they need to stay home. So what do you pay them for the week? Well, on Monday and Tuesday, they would get the equivalent of their regular salary. So what you're going to do is you're going to take their salary and you're essentially going to divide it by, their weekly salary divided by 40 hours and come up with what would be the equivalent of an hourly rate for that salary. You can only divide the salary by 40 hours, even if they normally would have worked 50 or 60 hours. We use the 40-hour threshold. So Monday and Tuesday, they're going to get paid basically 16 hours of what that hourly rate is that they would normally have. For Wednesday, Thursday, and Friday, we're going to look at the reason for their absence from work. If it's one of the qualifying reasons that allows them to get their full regular rate up to a maximum of $511 a day, then that's what they're going to get. If one of the reasons was to care for somebody else or to care for a child, right, and we're now capped at the $200 a day, then that's what they're going to get. either 2/3 of their regular rate or $200 a day. That's what they're going to get for Wednesday, Thursday, and Friday. So if they're taking so if they're taking that leave, we look at it kind of on a daily basis. Now, if they're taking intermittent leave, where let's just say, for example, and again, intermittent leave is only by agreement between the employee and the employer. So the employer has to agree to allow them to do intermittent leave. But let's take, for example, you've got an employee who is teleworking. They are able to, because of some childcare obligations, maybe they can commit to a work schedule of working from 8 to noon. So they can get 4 hours of work done, but they're going to need to take leave for 4 hours for the remainder of the day, because that's when they're going to then, maybe they're switching off with a co-parent. So from the 4 hours, and maybe the schedule is going to be 5 days a week. So they're going to work for 4 hours, 5 days a week, and they're going to take leave for 4 hours, 5 days a week. Then that week, they're going to be paid 20 hours of essentially what their salary would be. So again, figuring out what that hourly rate of the salary is for those 20 hours that they were actually working. And then they're going to get 20 hours at what is likely to be a reduced rate, right? And in this case, if it's because they're caring for a child, it's going to max at $200 a day, 2/3 of their regular rate. So really, it's going to max at $100 for those 4 hours because they're just working half of the day. This will not, as least as we understand right now from the Department of Labor, would not violate the salary basis test, because again, this is the employee is needing to take the leave. It's at their request that they're essentially reducing their hours, and they've got this leave available. Okay, if we have an employee who is taking extended family leave and qualifies to do so intermittently, and we agree, right, that's the big one, the employer has to agree, in what increments can the employee take the leave? It can be hours, days, weeks. This is completely, because this is by agreement, it is up to whatever standard you want to set as the employer. The example that the Department of Labor gave was, maybe you work out a modified schedule where the employee works, a couple hours in the morning, then they're off for a few hours, and then they come back for a few hours. I think you just, the guidance that we have from the Department of Labor is work as fast as you can with your employees to figure out what makes sense. You have the motivation that you want them to get the work done. So if you can do it in hours, that's great. If you feel like their job, you can only do it in days or weeks, then, and the employee agrees to that, then that's how you would do it. Okay, the 80 hours of paid sick leave. So are employees allowed to use partial number of hours per week, or are they required to use the 80 hours within the 2-week period? For example, if an employee works an average of 40 hours per week, but would like to use 20 hours per week for the next 4 weeks, is that permissible? And the answer to that is no. So the paid sick leave, right? So it's 2 weeks of paid sick leave. And if the person is themselves sick, right, and not teleworking, then they should be using it in continuous blocks until they are replaced back to work. If they are teleworking, they could choose to only use 20 hours in week 1 and 20 hours in week 2. But after week 2, we end the paid sick leave and we now convert over to the family medical leave, where it then becomes the use is only because they're caring for a child. So hopefully I haven't totally confused you on that. If I have, please drop some questions in the chat box and we can break that out and answer that into more detail. Yes, Sean is going to jump in real fast, so let me mute myself.
On that point, another thing that the Department of Labor told us is the 10 days for the, and this comes in with the intermittent leave a little bit, the 10-day unpaid period for the family medical leave expanded, they're actually now interpreting it as 2 weeks. And the way that it interacts with intermittent leave is you have to figure out what the employee normally works in a work week. And if they say they take a certain amount of hours as intermittent leave, then that only operates as a percentage of that work week that's been used. So the percentage of the 2 weeks. So it can get very confusing as how you calculate that when you're applying it against the 2 weeks unpaid and then the extra 10 weeks that are available after that as potentially paid at 2/3. Yeah, and I think the other way to phrase that last question is just, the 2 weeks is not a window within which to use the paid leave. It's just the tool used to figure out how much leave is available. And then after that, they can use that leave for any reason, as long as that reason continues throughout until December 31st, 2020.
Thanks, John. So we had a question, which is like, I thought if a salaried employee does any work during a day, you have to pay them their full salary for the day. So how does the intermittent leave work? So this is, so let me start with, you're correct. The general premise is that if a salaried employee does any work in a day, right, or really any work in the week, they're supposed to get their full salary. There are some exceptions, right, which is where the salaried employee is on their own choosing for personal reasons, right, to take a leave. And so if that employee is deciding that they need to take, paid sick leave or this FMLA plus leave, that overrides your otherwise obligation to pay them their salary for that day. And even if the intermittent leave is agreed upon, so you guys have agreed that they're going to work for 4 hours and they're going to take 4 hours of leave, then you can do a reduction to their salary for those 4 hours of leave because you're paying them basically their leave time for that. If there is no agreement on the intermittent leave and the employee, right, is maybe they don't, and they do any work that day, then they're going to need to be paid for that entire day. So it's to your advantage as an employer to agree, I think, to do intermittent leave for somebody who is teleworking because it allows you to do some reductions to the salary if you need to for that period that they're on the intermittent leave that you wouldn't be able to do if you did not agree to let them do intermittent leave. Okay, so now we're going to talk about poster notice requirements. We did get a couple questions about this. So all employers with less than 500 employees must post or distribute a notice about paid sick leave. The notice is available for the Department of Labor's website. We also have it on our website as well. If you just Google DOL COVID-19, you'll find their resource page and you can find it. It's available in both English and Spanish currently. You are at this point only required to post it in English, but they do have that Spanish version available. And they've indicated that they'll get some additional languages as well. This applies even if you are a small business or you are a healthcare provider, you still need to post the poster. So as long as you've got 500 employees or less, just put the poster up. Where do you post it? How do you post it? So for teleworking employees, you can distribute it by email, you can mail it to them, post it on an intranet, an external website, anywhere where you think reasonably they're gonna see it. For your on-site employees, put it in your break room, right? Where you're putting the wage order and all of your other documentation, you put it there. If people have different buildings or they report to different job sites and don't come into the office, then you need to have it wherever they can see it. So should the employer draft a new policy for these various leaves? There is no requirement aside from posting the poster that you otherwise have a written policy. However, I think it's always good to have a policy and distribute it to your employees so that they understand, more specifically some of those requirements and how it interplays. You can be very clear in your policy that this is only available from April 1st to December 31st, that it doesn't roll over into next year, they don't get paid out upon termination. You could also use the policy to talk about interplay or integration with other leaves. The policy could be used to talk about kind of the documentation they're going to have to submit or who they need to check in with if they need to use leave. So it's a good idea to have a policy. It's not required. So one of the other questions we did get, which is, so if you have a 10-day PTO policy, do you just give the PTO time additional and rely on the paid protection repayment, that's the CARES Act, to replace that amount? So the answer to that is it's a couple different things. So if you already have an existing PTO policy, these 80 hours or the FMLA plus time, those 10 weeks, is in addition to what you have under your PTO policy. So you cannot use the 10 PTO policy to satisfy these leave requirements. You need to give this in addition to your PTO policy. Related to that, before we jump to questions on furloughs, is we did get a question about, what can I do with respect to my existing PTO and sick leave policies, and can I make changes to that? And I'm not just being a lawyer here, but that question has a lot of layers to it. So you may potentially be able to make changes to existing PTO and sick leave policies, provided that in the sick leave context, you are still meeting the state mandated requirements of providing sick leave, right? So if your sick leave policy was just to give the 24 hours that the state requires, or what a city might require, you certainly can't change it to, you'd be in violation of those requirements if you made a change to it. If your PTO policy and your sick leave is more generous than that, then we need to look at the language of the policy. At no point can you take away a benefit that the employee has already earned. So if the employee under your policy has already accrued a certain amount of PTO at this point in the year, you cannot change the policy so that they lose that. It may very well be possible to change the policy on a prospective basis. So to lower the accrual amounts, or make some adjustments to caps. I would, again, it's not just the lawyer in me, but I would strongly, strongly encourage you to work with legal counsel on those changes so that you don't run afoul of other requirements. Okay, so with that, I'm going to send it back to Sean, who's going to talk about some furlough information.
Great, and these are simple questions, and they're really important to understand because we are operating on very little guidance, which means that there's a lot of risk involved if you don't follow it and something comes up in the law and it changes and you're left in a very bad position. And these questions involve final payouts and furloughs. And so when are final payout obligations triggered? When you've got an employee that's on furlough. And again, remembering that this term furlough is a not specifically legal term of art. It's a common term used to basically tell an employee that we don't have work for you, or we're not assigning you to work for this given period or for the unforeseeable future. The Department of Labor Standards Enforcement, which is the California agency that has part of its charge to enforce the California Labor Code through including the Labor Commissioner's Office, has taken the position about 24 years ago that when you furlough an employee beyond their normal pay period length, so if you've got an employee on a biweekly pay period, 14 days, and you furlough them beyond the 14 days, your final pay obligations to that employee, including all wages owed in that pay period and all accrued vacation and any other accrued PTO that you might normally pay out, it's due at the end of that pay period. So keep that in mind when you're furloughing employees and they've got accrued vacation or other types of vacation-like wages. Does not include things like emergency paid sick leave under this act. It does not include things like California's paid sick leave, which requires those 3 days or an equivalent to it. But it is going to implicate PTO, vacation, things like that.
So, Sean,
So the one caveat to what Sean just said is triggering the final pay obligations is they are triggered at the start of the furlough. So if we know that the furlough is going to last for more than 10 days, at the start of the furlough is when those final pay obligations are triggered.
Yes. Thank you. Got rid of the echo. Okay, great. The next is, should we, and so there's actually another DLSC opinion as well, even earlier before that says when a furlough with a definite return to work date does not exceed 10 days, that will not result in a termination. So if you put an employee on a furlough today for 10 days and you do bring them back, you haven't terminated them under the final pay obligations of California, and you don't need to pay out that accrued benefit. The next question on here, should we and can we require furloughed employees to take their accrued vacation and sick leave during the furlough? Again, if we're operating under the guidance we just gave you for the first question there, which is we pay them under those certain circumstances, the Department of Labor Standards Enforcement has also said that you can require employees to use their accrued vacation or PTO, as long as that requirement is fair and reasonable. So if you're putting that employee on, let's say, a 10-day furlough, you can ask them and tell them to use accrued vacation. You have to be very careful about sick leave, though, because you don't want to start treating your sick leave like vacation. So a lot of sick leave that California companies offer actually follows the California paid sick leave rules, which say you can only use this in a certain amount of circumstances under certain circumstances. If we start treating that like vacation, you could accidentally turn it into a PTO equivalent, which then you may be required to pay out at the end of employment. So you want to continue to treat that like paid sick leave under the circumstances that that paid sick leave is usable. For things like vacation or PTO, where it's meant to be used at any given point for any given reason, you can require employees to use that if it's fair and reasonable and you give them notice that you're doing it. And we're going to switch it over now to Karen on the last, nope, that was it. She's going to cover one last topic.
Okay, so before I jump to our last topic, we've got a couple questions that are coming out on the furloughs. So the first question is, what if you don't know how long the furlough is going to last? And that's a fair point, but I think it's safe to say that if you are furloughing people because your business has been forced to close because of the shelter in place, right? You're a non-essential business and you can no longer operate. We know that that's going to last for more than 10 days, right? We now have a new end date, or unless it gets moved again, right? We have an end date for that shelter in place. So at the time you are placing the person on furlough, I think the question is, do you reasonably expect to return them within 10 days or by the end of the pay period? The answer to that is no. Then this old DLSE opinion would suggest that the final pay obligations have been triggered. It's unclear, just to be honest, whether the DLSE will enforce this in light of sort of this pandemic. I submitted a question to them earlier in the week. They have an FAQ portal, and they have not yet addressed or answered that in any of their guidance. On the sick leave piece of it, clients are doing a variety of different things, and we want to talk through sort of the risks and benefits to these in more detail. But what do you do with the accrued vacation for somebody who's going to be furloughed for the next month? Strict compliance would say you need to pay it out on the day of the furlough. I do have some clients who are giving the employee the option to use the vacation, have it right away, or to keep it in their bank so that they have the time available when they return to work, right? So if they have a planned vacation in October and they know they're going to want vacation available in October, they may choose to not have it paid out at this point. But I think that's got to be a discussion and a decision that's really left up to the employee, so that you don't avoid sort of a willful failure to pay that. So another question just says, what if we plan to have an employee come back once we have the work, but the furlough is more than 10 days? Does that count as a termination and we have to rehire? So that's a slightly different question, right? So the question of whether or not you have to rehire is so if you have just told somebody, I don't have any work for you, I am going to furlough you, you're going to be, off for the next month, they are still an employee as far as like your W-9 and all that paperwork goes. And you would not then have to rehire and onboard them once the work picks up and you bring them back. You could just go right back to, here's your shift, let's start working. If, however, you decide that you are just going to do a full-on termination, right, and sever that employment relationship, then yes, if work picks up and you want to bring the person back, you would need to do the rehire. Okay, so if we pay semi-monthly and furlough in the middle of the pay period and bring them back in the middle of the next pay period, are we okay? Or do we have to bring them back by the end of the original pay period? I don't have an answer for you. So there's what the DLSE says, and again, this is guidance from like 1993 and 1996, but it says there's two scenarios where the furlough triggers the final pay obligations. And that is where the furlough is going to last more than the pay period, right? Their expected return to work date is something beyond the pay period, or the furlough lasts for more than 10 days. So I don't know how the department would view that situation. What are best practices with rescinding job offers given potential furloughs? Look, I think that, if you need to rescind a job offer, you have a couple choices, right? You could tell the employee, or the applicant that, they're not able to start at this time, and you can push out their start date and say, now looks like your projected start date is going to be X. You could just say, look, we've had a change in circumstances, and unfortunately we need to rescind the offer. This is going to be, I think, very specific to the, your business, what the employee was going to be doing, what your needs might be. Yes, what promises were made to the employee as far as, compensation and work. I can say anecdotally, I have seen some employers face this decision, and they have considered offering the employee or the applicant, right, the new hire, a severance. I'm basically saying in exchange for, an understanding that their offer is being rescinded. I don't know that that's required. I think that's just more a kind of, yes, a risk management issue. Okay, so before I jump to these last two questions, let me just mention, and again, keep the questions coming. We do have a few more minutes. Some of you may have seen that San Jose City Council is moving forward on a paid sick leave ordinance. The final rule is in the process of being drafted, and we expect to vote by City Council on that next week. What we know so far is that the 80 hours of paid sick leave that that employers will be required to provide will only apply if the employer is not already providing 80 hours of paid sick leave. So the intention, as we understand it right now from City Council, is that if you are complying with this federal paid sick leave, you would not additionally have to do another 80 hours under the San Jose paid sick leave. It's really trying to target those employees who are sort of being left out of the federal paid sick leave, or the employer doesn't already have a more generous policy. One thing I'll mention is if you are in Santa Clara County is now requiring social distancing protocols for those businesses that are still operating. You can find in the shelter-in-place order, there is an Exhibit A. They give you a template protocol to use that you can work through and make sure that you post it and you distribute it to your employees. We also did have some questions on unemployment. My advice, and I think we said this on Tuesday, is that you don't make any representations to your employees with respect to what they're going to get for unemployment, and that you direct them to the unemployment office. There's a lot that's changing in what they may or may not qualify for. Okay, so I'm going to answer these last two questions, Matt. I think we've got a few, and then or we'll try to answer them. So the first one is, we're an essential business and business is soft. We're furloughing a week at a time and then extending it another week if needed. Does this trigger a payout at some point? So I think if you are furloughing for a week and you have a good faith belief that you'll be able to return the person the following week, no. I think if you are furloughing at a week at a time to try to avoid your obligations under triggering final pay, then I could see the department saying that did trigger it. So I think it's just going to have to be fact specific, and do you have a reasonable belief that you're going to be able to bring them back the next week? Would PTO payouts be considered payroll grants after we receive a loan from the SBA under the PPP CARES Act? So let me just tell you, unfortunately, Sean and I are not in a position to advise as to the CARES Act and the loans and what's going to qualify for that. So I'm going to have to save that for another SVO member resource on that piece of it. And maybe, Matt, that's a good point to sort of transition back to you.
Yeah, thank you very much, Karen. Thank you, Sean. That's actually a really good question. We're getting a lot of questions about how to navigate the SBA loan process and the grants that that exist underneath that program. And actually, while you guys were talking, I was chatting with staff about us looking at a webinar or a seminar on that topic about how to navigate the SBA loans, because I think that's the next big challenge that we all face. I think it's we're right up against 11 o'clock. I do like to start on time, and I do like to end on time. I want to thank both. If you have additional questions, I know Karen and Sean would be happy to take them. They're obviously very passionate about what they do. Very challenging time for each of them. You can find them, both Karen and Sean, at Hopkins and Carley out of the San Jose office in their employment division. So give them a virtual applause for being here and supporting all of the businesses that were on the program today. So thank you, Sean and Karen, really do appreciate it for doing part 2. We will record this. We will put it up on the SVO website. So look for that here shortly. And then next Tuesday, we'll hear from Petronovich Pugh and Company on tax updates and economic relief measures that are now available through the CARES Act, the Coronavirus Aid Relief and Economic Security Act. Everybody's got an acronym, so now it's the CARES Act. So check out our website, continue monitoring our website for updates on the COVID-19 information resources. Let's continue to maintain our social distance and our shelter-in-place orders, and hope everybody stays healthy and safe during this time. Again, thank you, Sean and Karen, and go out and have a great day, you guys. Thank you. Before the rain comes, get outside before the rain comes today. All right. Thank you very much. Appreciate it. Bye.